What's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. If you're ever in Minnesota and you run into any legal issues or concerns, please look me up and I can maybe help you out. All right, guys. So today is a big news day in the legal world. Of course, this is the long-awaited Supreme Court ruling in Masterpiece Cake Shop Limited versus the Colorado Civil Rights Commission, more improperly known as the Gay Cakes decision or something along those lines. This is the case where a gay couple requested a cake from a baker in Colorado, and he turned them down on religious grounds, saying that to make a cake for a same-sex wedding would violate his sincerely held religious beliefs. They said that's not fair. They contacted the Colorado Civil Rights Commission in a long roundabout story that we'll talk about in depth in just a moment. And the Civil Rights Commission agreed with the same-sex couple, saying that the baker could not do that was a violation of the state law and about public accommodations, and that he had to basically change his policies, and he had to make cakes for same-sex couples, even if it violated his sincerely held religious beliefs. All right, so that's... Then he appealed that to the Colorado Court of Appeals. They agreed with the Civil Rights Commission, so he appealed it then to the Supreme Court of the United States after the Colorado Supreme Court declined to hear it. And the Supreme Court of the United States rendered its decision today. It was argued December 5th, 2017. That means we have waited 6 months for this decision. And it's not that, the total document is 26 pages. Kennedy's decision is about 11, which is brief in regards to recent Supreme Court cases. So 6 months for 11 pages. Good job moving at the speed of light. But that's where we're stuck with. So tonight I'm drinking some Maker's Mark. And most importantly, we're going to talk about how a bunch of people are wrong about what happened here. And it's really important to understand what's going on in a Supreme Court decision, because it's not straightforward. So you've probably seen some sort of tweet or post about this saying something along the lines of, Supreme Court says it's okay for bakers to refuse to bake cakes for gay couples. And depending on where you go, the language could have been more or less harsh. It doesn't really matter. And they could be in favor of that or opposed to that, and that can come through. That's not what the Supreme Court said in this case. And so, along with we're going to read through the decision, and it'll become more and more apparent, and I'll kind of highlight the points as we go. But we're going to talk about why people who haven't suffered through constitutional law classes often get this stuff wrong. Because when you're looking at a Supreme Court case, like, one of the most important parts of it is, what question is the Supreme Court answering? So if you think in this case that the question is, can a baker refuse to bake cakes for a same-sex couple when that violates his sincerely held religious beliefs, you're wrong. You're wrong from the start. That's not the question in this case. So that cannot be the takeaway. It just isn't. That it may be the case that is so, but the Supreme Court has not yet decided that is so. And to use this case to state that would be a little bit of a stretch. And so we're going to talk about that. So one final point before we really jump into this is, I am not going to I'm not going to go through all the concurring opinions and the dissenting opinion because it'll just be way too long of a video. And they matter a little bit for argumentative purposes, but they don't matter today. They matter decades from now, probably not, maybe 5 to 10 years from now at best, they might matter. But the way this type of case is going and the sheer number of these types of cases that have happened, we're going to see another case like this come to the Supreme Court, and they're going to have to clarify the position more because right now is not good enough. They haven't done good enough of a job in telling us what to do. Right now, a baker has no idea whether or not he has to bake this cake. Okay, so, and that's unacceptable. That's an unacceptable legal position to be in. At the onset, I will provide my biases up front. I don't think anybody should be forced to do anything for anyone. Like, I'm going to talk a lot about public accommodations and civil rights laws. I don't necessarily think they're a bad thing. That's not what I'm trying to say. But I don't think they comport with the ideas of freedom. So my default perspective is that people should be able to do business with whomever they want. They should be able to refuse business to whomever they want. Next part of my biases, I would not refuse business to anybody based on their beliefs, national origin, sexual orientation. I don't care. I don't think, if I were a baker, I would bake the cake 100% of the time because I am a person who likes to do business with people and make money. And I don't think that someone else's, that me baking a cake for them is somehow an endorsement of their activity. That doesn't mean that I think other people need to think that way. That's just how I think, okay? That's me personally. So if you come into my law office and you ask me to, do a, I don't really do family law, but if you ask me to write a prenup for a same-sex couple, of course I would write a prenup for a same-sex couple, the same I would write a prenup for anybody else. That's me. So I don't refuse service to people based on that. I only, and I don't really refuse service to anyone, but I would discourage people from hiring me if I think there's someone out there who would be a better fit. But, I leave that hiring decision to the customer, and I don't tend to refuse service. That's not really my role as a lawyer to refuse things, but it would be a weird situation. So those are my biases. I don't think anybody should be forced to do anything by the government in regards to how they conduct business. But personally, I would not refuse service to anybody because I just don't see that my work is an affirmation of people's beliefs or actions. And that's a good thing because I'm a criminal defense attorney. So me defending someone and giving them the best shot that they have doesn't mean that I support what they may or may not have done. All right? Anyway, let's get moving. So here's the brief background, the synopsis of the case. Cake shop and its owner sought review of the Colorado Civil Rights Commission's decision and issuance of cease and desist order in a proceeding arising from shop's refusal to sell a wedding cake to a same-sex couple, requiring shop and owner not to violate Colorado Anti-Discrimination Act by discriminating against potential customers because of their sexual orientation. Colorado Court of Appeals affirmed, and then cert was granted. Holding, the Supreme Court, Justice Kennedy held that the Commission did not comply with the Free Exercise Clause's requirement of religious neutrality. All right, so there's that. These are all Westlaw keynotes and headnotes. These are not part of the decision, and we're not going to read through them. You're welcome. Here's the syllabus. Masterpiece Cake Shop Limited is a Colorado bakery owned and operated by Jack Phillips, an expert baker and devout Christian. In 2012, he told a same-sex couple that he would not create a cake for their wedding celebration because of his religious opposition to same-sex marriages that Colorado did not then recognize, but that he would sell them other baked goods, e.g. birthday cakes. The couple filed a charge with the Colorado Civil Rights Commission pursuant to the Colorado Anti-Discrimination Act, or CADA, which prohibits, as relevant here, discrimination based on sexual orientation in a place of business engaged in any sales to the public and any place offering services to the public. Under CADA's administrative review system, the Colorado Civil Rights Division first found probable cause for a violation and referred the case to the commission. The commission then referred the case for a formal hearing before a state administrative law judge, who ruled in the couple's favor. In doing so, the administrative law judge rejected Phillips' First Amendment claims that required him to create a cake for same-sex wedding. His First Amendment claims. The claim is, that requiring him to create a cake for the same-sex wedding would violate his right to free speech by compelling him to exercise his artistic talents to express a message which he disagreed, and would violate his right to the free exercise of religion. Both the Commission and the Colorado Court of Appeals held the Commission's actions in this case violated the free exercise clause. So, I talked about earlier, let's see here. Oh, this is still the syllabus. Let's skip the rest of this syllabus, because all of this stuff is going to be said down below. So let's jump to the opinion. The reason I don't want to waste your time reading the same thing over and over. And I do want to take some of that otherwise wasted time and talk about the question in this case, because this is important. The question in this case, as I stated, is not, can a baker refuse to bake a cake based on the same-sex status of someone who comes into their shop? The answer to that question seems to be no, they can't refuse it, even after this ruling. What this ruling's question is did the Colorado, what was that? What was that stupid acronym? Colorado Anti-Discrimination Act. Okay, so can the Civil Rights Division under the Colorado, what was it? Terrible at remembering this. Colorado Anti-Discrimination Act. So can the Civil Rights Division under the Colorado Anti-Discrimination Act, let's see. No, sorry. And this is a hard part. So I'm going to go through the whole thought process with you, because it's not easy to figure out what the question is in these cases, but it is crucial to do so and to do it with some precision. And in the con law class I took, we had to sit there and do this until our professor was satisfied that we had taken the right question out of the case. So I apologize if this seems a little weird, but the question in this case, I think, we'll see once I actually get it out loud, is did the civil division in applying the Colorado Anti-Discrimination Act violate the free exercise clause of the Constitution of the United States by applying the Anti-Discrimination Act non-neutrally with respect to the religion of Masterpiece Cakes? I think that's the question. I think so. But you get the idea here. The idea here is not whether or not a baker can refuse service or not. The idea in this case is, under these facts, under the baker's refusal and then how he proceeded through the administrative law judge and the Civil Rights Commission or whatever, Civil Rights Division, when they're applying the Anti-Discrimination Act, the Colorado Anti-Discrimination Act, did they violate his First Amendment rights to religion by ruling on this in a manner that was not neutral towards his religion, but in this case was actually hostile towards it? And the court here says, yes, they violated his First Amendment rights by applying the laws in a hostile way to his religion rather than in a neutral way. So that's the question. That is what matters here. That is why this guy wins his case, and that is why the next baker to deny to make a cake for a same-sex couple cannot really rely on this case. They would have to not bake the cake, and then the whatever tribunal they went before, whatever civil rights panel or lower court that they had their case heard in front of, would then have to disrespect their religion or be hostile to it for this case to apply. Outside of that context, it doesn't apply. So if you see someone saying giant win for First Amendment, I mean, yes, it is a big win for the First Amendment, but not in the way most people are taking this. Okay, so a baker may still be forced under state law to bake a cake for a same-sex wedding. May. It is an unresolved question, and you cannot rely on this case to answer it. So, I'm sure I'm going to get questions about this. I live in a part of the country that has, at least in a part of Minnesota, that has a strong conservative Christian contingent of people who, they may be put in this position, and my advice to them will be the same. Just make the cake. Make the cake or prepare for a lawsuit. That's the two routes you have to go. All right, so this opinion was written by Justice Anthony Kennedy, who I think is somewhere around 164 years old, but we'll bear with it. I think he's also roughly the size of a Muppet. So Justice Kennedy delivered the opinion of the court. Let's get into this. In 2012, a same-sex couple visited Masterpiece Cake Shop, a bakery in Colorado, to make inquiries about ordering a cake for their wedding reception. And brief side thing. For those of you watching at home, you just got the TLDR just a minute ago of this whole video at 15 minutes. So 15 minutes in, you can actually, I don't want you to stop watching. If you want to learn about how the Supreme Court does stuff, by all means, keep going. But if you want to know the answer to what this case means, I just told you, and that's the ultimate result we're going to get to. So, spoiler alert, warning bells or whatever. Anyway, but hang out with me through the rest of it, and we'll see what the court actually didn't like and did like and all that stuff. All right, the shop's owner told the couple that he would not create a cake for their wedding because of his religious opposition to same-sex marriages. Marriages that, at the time, the state of Colorado itself did not recognize at that time. The couple filed a charge with the Colorado Civil Rights Commission alleging discrimination on the basis of sexual orientation in violation of the Colorado Anti-Discrimination Act. The commission determined that the shop's actions violated the act and ruled in the couple's favor. The Colorado state courts affirmed the ruling and its enforcement order, and this court now must decide whether the commission's order violated the Constitution. There's hints to that question. This case presents difficult questions as to the proper reconciliation of at least two principles. The first is the authority of a state and its governmental entities to protect the rights and dignity of gay persons who are or wish to be married, but who face discrimination when they seek goods and services. The second is the right of all persons to exercise fundamental freedoms under the First Amendment, as applied to the states through the 14th Amendment. The freedoms asserted here are both the freedom of speech and the free exercise of religion. The free speech aspect of this case is difficult. For few persons who have seen a beautiful wedding cake might have thought of its creation as an exercise of protected speech. And let me pause, because this is where Anthony Kennedy's age starts to show. When we have basically an entire network, like the Food Network, running nonstop shows, Cake Boss, Cupcake Wars, and any other type of dessert show or dessert show competition or anything like that, constantly showing the artistry that is possible with cakes, desserts, or the culinary arts in general. you have to have grown up in a time when the culinary arts didn't matter, right? Like 40s and 50s. They mattered, but not in the way that we celebrate them now. We give, we have people paying tens of thousands of dollars to bakers for specialized cakes. What was it? Chelsea Clinton's wedding? I think her cake was 10 grand, right? Something like that. So the idea that a cake might not be that a cake might be protected speech is weird. That's not. I don't think if most Americans stopped for just a moment and said, is a piece of cake or is a cake, a wedding cake, a work of art? They'd say, well, I mean, it depends on the cake. But the amount of money people are dropping on cakes now and the amount of time that goes into picking them, you're not getting a giant sheet cake baked in a prison tray. You know, you're paying thousands of dollars oftentimes for a very elaborate cake, might be multi-tiered and have all sorts of work on it. And you are very much paying for the artistic ability of the person making the cake. And this goes well beyond wedding cakes, okay? I mean, I know people who make phenomenal cupcakes, and each cupcake in itself is a work of art. Like the work that they put into them if you're buying this type of cupcake. So the idea that wedding cake might not be protected speech is actually silly to me. That's the silly proposition that it might not be protected speech. I think we have overwhelming evidence that a cake would be protected speech. If you're going to a baker who specializes in a certain type of thing, it's probably protected. And think of it this way. Let me see. You can go to Target. No, that's a bad example because that would be protected speech too. But okay, still, you can go. You can take a picture, right? Or you can pay a photographer to take a good picture. There's a vast difference there, but the photographer's picture is undoubtedly protected speech. If you're getting a photo booth, it might not be protected speech. It probably is, but you get the gist here. Anyway, I'm rambling and I'm bad at it. So let's move on. So where we left off, for few persons who have seen a beautiful wedding cake might have thought of its creation as an exercise of protected speech. I mean, maybe I'm just a lawyer and that, of course, I think of it that way. But this is an instructive example, however, of the proposition that the application of constitutional freedoms in new contexts can deepen our understanding of their meaning. One of the difficulties in this case is that the parties disagree as to the extent of the baker's refusal to provide service. If a baker refused to design a special cake with words or images celebrating the marriage, for instance, a cake showing words with religious meaning, that might be different from a refusal to sell any cake at all. In defining whether a baker's creation can be protected, these details might make a difference. Right. If you're selling just a generic sheet cake, that's different than selling a beautiful wedding cake, as Anthony Kennedy describes it. The same difficulties arise in determining whether a baker has a valid free exercise claim. A baker's refusal to attend the wedding to ensure that the cake is cut the right way, or a refusal to put certain religious words or decorations on a cake, or even a refusal to sell a cake that has been baked for the public generally, but includes certain religious words or symbols on it, are just three examples of possibilities that seem all but endless. Notice none of those happened here, and none of them are important. Whatever the confluence of speech and free exercise principles might be in some cases, the Colorado Civil Rights Commission's consideration of this case was inconsistent with the state's obligation of religious neutrality. The reason and motive for the baker's refusal were based on his sincere religious beliefs and convictions. The court's precedents make it clear that the baker, in his capacity as the owner of a business serving the public, might have his rights to the free exercise of religion limited by generally applicable laws. So, what they're saying there is that whole thing in the Constitution where it says, your rights for the First Amendment, your right to the free exercise of religion shall not be infringed, except when we need to infringe it. Right? Like that's the Supreme Court's answer to everything is it shall not be infringed except when we want to. And they are saying that right can be infringed. It can be limited by generally applicable laws. What it cannot do is be limited by laws or acts of government. When they say laws here, replace it with acts of government that are specifically non-neutral rather than generally applicable. Okay? Still, the delicate question of when the free exercise of his religion must yield to an otherwise valid exercise of state power needed to be determined in an adjudication in which religious hostility on the part of the state itself would not be a factor in the balances the state sought to reach. That requirement, however, was not met here. When the Colorado Civil Rights Commission considered this case, it did not do so with religious neutrality that the Constitution requires. Given all these considerations, it is proper to hold that whatever the outcome of some future controversy involving facts similar to these, the Commission's actions here violated the Free Exercise Clause and its order must be set aside. Again, this is Anthony Kennedy saying very specifically, this case does not answer the question of whether or not a baker can refuse a same-sex couple a wedding cake. It is not answering that question. It is merely saying that in this case, the Civil Rights Commission acted poorly. Okay, Masterpiece Cake Shop is a bakery in Lakewood, Colorado, suburb of Denver. The shop offers a variety of baked goods, ranging from everyday cookies and brownies to elaborate custom-designed cakes for birthday parties, weddings, and other events. Jack Phillips is an expert baker who has owned and operated the shop for 24 years. Phillips is a devout Christian. He has explained that his main goal in life is to be obedient to Jesus Christ and Christ's teachings in all aspects of his life, and he seeks to honor God through his work at Masterpiece Cake Shop. One of Phillips' religious beliefs is that God's intention for marriage from the beginning of history is that it is and should be the union of one man and one woman. To Phillips, creating a wedding cake for a same-sex wedding would be the equivalent to participating in a celebration that is contrary to his own most deeply held beliefs. Phillips met Charlie Craig and Dave Mullins when they entered his shop in the summer of 2012. Craig and Mullins were planning to marry. At that time, Colorado did not recognize same-sex marriages, so the couple planned to wed legally in Massachusetts and afterwards to host a reception for their family and friends in Denver. To prepare for their celebration, Craig and Mullins visited the shop and told Phillips they were interested in ordering a cake for, quote, our wedding. They did not mention the design of the cake they envisioned. Phillips informed the couple that he does not create wedding cakes for same-sex weddings. He explained, I'll make your birthday cake, shower cake, sell you cookies and brownies. I just don't make cakes for same-sex weddings. The couple left the shop without further discussion. And let's be honest, everyone, that's where the case should have ended. And I don't mean this to be as a slight towards same-sex couples and say just live with the discrimination. Like, that's not actually my point. My point is, if someone doesn't want to do business with me, I certainly don't want to do business with them, and I don't want to force via the state them to do business with me, because I don't think then that I'll be getting what I'm asking for, right? Like, I just don't. So for me, that's where it goes. Like, if I walked into a bar in order to drink and they said, we don't serve bearded lawyers, get out, you giant idiot, then I would leave the bar and not want to force my bearded lawyering upon them. That's not my job. So, I mean, it kind of is my job, but that's not my goal in life. And that's not what I would do. But they went on. The following day, Craig's mother, who had accompanied the couple to the cake shop and been present for their interaction with Phillips, telephoned to ask Phillips why he had declined to serve her son. Phillips explained that he does not create wedding cakes for same-sex weddings because of his religious opposition to same-sex marriage, and also because Colorado, at that time, did not recognize same-sex marriages. He later explained his belief that, quote, to create a wedding cake for an event that celebrates something that directly goes against the teachings of the Bible would have been a personal endorsement and participation in the ceremony and relationship that they were entering into. See, and I disagree with that, but that's his position, that's his belief. So, for most of its history, Colorado has prohibited discrimination in places of public accommodation. In 1885, less than a decade after Colorado achieved statehood, the General Assembly passed, quote, an act to protect all citizens in their civil rights. which guaranteed full and equal enjoyment of certain public facilities to all citizens regardless of race, color, or previous condition of servitude. That's from the 1885 Colorado Sessions Laws. A decade later, the General Assembly expanded the requirement to apply to, quote, all other places of public accommodation. That's the 1895 laws. Today, the Colorado Anti-Discrimination Act carries forward the state's tradition, of prohibiting discrimination in places of public accommodation, amended in 2007 and 2008 to prohibit discrimination on the basis of sexual orientation as well as other protected characteristics. CADA, in relevant part, provides as follows. And this is very standard language for these acts that most states, if not all of them, have. It is a discriminatory practice and unlawful for a person directly or indirectly to refuse, withhold from, or deny to an individual or a group because of disability, race, creed, color, sexual orientation, marital status, national origin, or ancestry the full and equal enjoyment of the goods, services, facilities, privileges, advantages, or accommodations of a place of public accommodation. The Act defines public accommodation broadly to include any, quote, place of business engaged in the sales to the public and any place offering services to the public, but excludes, quote, a church, synagogue, mosque, or other place that is principally used for religious purposes. CADA establishes an administrative system for the resolution of discrimination claims. Complaints of discrimination in violation of CADA are addressed in the first instance by the Colorado Civil Rights Division. The division investigates each claim, and if it finds... Sorry, this is so weird looking off to the side from you guys. Let me do that better. Where did we go? And if it finds probable cause that CADA has been violated, it will refer the matter to the Colorado Civil Rights Commission. The commission, in turn, decides whether to initiate a formal hearing before a state administrative law judge, who will hear evidence and argument before issuing a written decision. The decision of the ALJ must be appealed to the full commission, may be appealed to the full commission, a 7-member appointed body. The commission holds a public hearing and deliberative session before voting on the case. If the commission determines that the evidence proves a CADA violation, it may impose remedial measures as provided by statute. Available remedies include, among other things, orders to cease and desist as a discriminatory policy, to file regular compliance reports with the commission, and to, quote, to take affirmative action, including the posting of notices setting forth the substantive rights of the public. Colorado does not permit the commission to assess money damages or fines. Oh, sorry, that's down here. So there is a different case right now where a photographer or florist, I think it was a photographer, was ordered to pay $130,000 for a similar sort of event. And that is not the case here. They cannot impose monetary fines. Craig and Mullins filed a discrimination complaint against Masterpiece Cake Shop and Phillips in August 2012, shortly after the couple's visit to the shop. The complaint alleged that Craig and Mullins had been denied, quote, full and equal service at the bakery because of their sexual orientation, and that it was Phillips' standard business practice not to provide cakes for same-sex weddings. The Civil Rights Division opened an investigation. The investigator found that on multiple occasions, Phillips turned away potential customers on the basis of their sexual orientation, stating that he could not create a cake for a same-sex wedding ceremony or reception because his religious beliefs prohibited it and because the potential customers, quote, were doing something illegal at that time. The investigation found that Phillips had declined to sell custom wedding cakes to about 6 other same-sex couples on that basis. The investigator also recounted that, according to affidavits submitted by Craig and Mullins, Phillips' shop had refused to sell cupcakes to a lesbian couple for their commitment celebration because the shop, quote, had a policy of not selling baked goods to same-sex couples for this type of event. I'm guessing a commitment celebration would be like an engagement celebration, something like that. Or maybe it's a non-wedding wedding where we got married, but we can't be married under the state law, so we can't actually like get married, but this is our celebration where we're promising to be with each other and screw the state. And everybody should be doing that. Honestly, screw the state. The state needs to get out of marriage in general and stop telling people who and what is a valid marriage. But, you know, that's That's my opinion as well. And not welcome here. Okay. Based on these findings, the division found that probable cause that Phillips violated CADA and referred the case to the Civil Rights Commission. The commission found it proper to conduct a formal hearing, and it sent the case to a state administrative law judge. Finding no dispute as to the material facts, the ALJ entertained cross motions for summary judgment and ruled in the couple's favor. So they didn't, they didn't find any disputes between the two facts. So they allowed each of the parties to submit motions, which would be in support of their read of the law, their version of the law that should be applied. And then the judge would determine between them. So we're not talking about oral argument. We're not talking about trial. There's no witnesses in cross-exam because the facts in this case, he says the facts are consistent between both of the parties. So we don't need to resolve them. If you don't know, the point of a trial is to find the facts. That's the whole point of a trial. That's what all that evidence is for. Find the facts. And then once we have the facts, we can apply the law. If it only worked out that easily, but that's the goal. Okay. So let's see. The ALJ first rejected Phillips' argument that declining to make or create a wedding cake for Craig and Mullins did not violate Colorado law. It was undisputed that the shop is subject to state's public accommodation laws, and the ALJ determined that Phillips' actions constituted prohibited discrimination on the basis of sexual orientation, not simply opposition to same-sex marriage, as Phillips contended. Phillips raised two constitutional claims before the ALJ. He first asserted that applying CADA in a way that would require him to create a cake for a same-sex wedding would violate his First Amendment rights to free speech by compelling him to exercise his artistic talents to express a message with which he disagreed. This is a good argument and a very good point. The ALJ rejected the contention that preparing a wedding cake is a form of protected speech and did not agree that creating Craig and Mullins' cake would force Phillips to adhere to an ideological point of view. In my opinion, that is a completely wrong perspective from the court, because forcing someone to do something expressive is a violation of their free speech. Period. Applying CADA to the facts at hand and the ALJ's view did not interfere. Applying CADA to the facts at hand and in the ALJ's view did not interfere with Phillips' freedom of speech. Phillips also contended that requiring him to create cakes for same-sex weddings would violate his right to the free exercise of religion, also protected by the First Amendment, citing this court's precedent in Employment Division, Department of Human Resources of Oregon versus Smith. The ALJ determined that CADA is a, quote, valid and neutral law of general applicability, and therefore that applying it to Phillips in this case did not violate the free exercise clause. The ALJ thus ruled against Phillips in the cake shop and in favor of Craig and Mullins on both constitutional claims. The commission affirmed the ALJ's decision in full. The commission ordered Phillips to cease and desist from discriminating against same-sex couples by refusing to sell them wedding cakes or any product they would sell to heterosexual couples. It also ordered additional remedial measures, including comprehensive staff training on the public accommodation section of CADA and changes to any and all company policies to comply with this order. The commission additionally required Phillips to prepare quarterly compliance reports for a period of 2 years, documenting the number of patrons denied service and why, along with a statement describing the remedial actions taken. Oi, you got a permit for that denial? Phillips appealed to the Colorado Court of Appeals, which affirmed the commission's legal determinations and remedial order. The court rejected the argument that the commission's order unconstitutionally compels Phillips and the shop to convey a celebratory message about same-sex marriage. The court also rejected the argument that the commission's order violated the free exercise clause, relying on this court's precedent in Smith. The court stated that the free exercise clause, quote, does not relieve an individual of the obligation to comply with a valid and neutral law of general applicability on the ground that following the law would interfere with religious practice or belief. The court concluded that requiring Phillips to comply with the statute did not violate his free exercise rights. The Colorado Supreme Court declined to hear the case. Phillips sought review here, and this court granted cert. He now renews his claims under the free speech and free exercise clauses of the First Amendment. All right. So that's section 1. Section 2 and 3 are a little shorter. I think, maybe not. Our society has come to the recognitions that gay persons and gay couples cannot be treated as social outcasts or as inferior in dignity and worth. For that reason, the laws and the Constitution can, and in some instances must, protect them in the exercise of their civil rights. The exercise of their freedom on terms equal to others must be given great weight and respect by the courts. At the same time, the religious and philosophical objections to gay marriage are protected views, and in some instances protected forms of expression, as this court observed in Obergefell versus Hodges. Obergefell versus Hodges is the case which the Supreme Court stated that same-sex marriage is a fundamental right and is protected by the 14th Amendment among other amendments, like the 9th probably. Anyway, so same-sex marriage is a fundamental right, and all states have to recognize it now, since 2015. The First Amendment ensures that religious organizations and persons are given proper protection as they seek to teach the principles that are so fulfilling and so central to their lives and faiths. Notice Kennedy is quoting Obergefell versus Hodges while slightly undermining a portion of it. So that's a good tip, by the way. When your authority comes to a case that is logically hostile to you but agrees in principle with that particular point, it's a good authority to use. And Kennedy used it for a reason. Nevertheless, while those religious and philosophical objections are protected, it is a general rule that such objections do not allow business owners and other actors in the economy and in society to deny protected persons equal access to goods and services under a neutral and generally applicable public accommodations law. Citing Newman versus Piggy Park Enterprises and Hurley versus Irish American Gay, Lesbian, and Bisexual Group of Boston. Provisions like these are well within the state's usual power to enact when a legislature has reason to believe that a given group is a target of discrimination, and they do not, as a general matter, violate the First or 14th Amendments. As a general matter, not as a specific matter. When it comes to weddings, it can be assumed that a member of the clergy who objects to gay marriage on moral and religious grounds could not be compelled to perform the ceremony without denial of his or her right to the free exercise of religion. I don't know if it can be assumed that anymore, though. Like, I really think that is coming down the line. Maybe it's okay for clergy, but what about non-clergy? What about people who are given licenses by the state and stuff like that? It may not be okay. This refusal would be well understood in our constitutional order as an exercise of religion, an exercise that gay persons could recognize and accept without serious diminishment to their own dignity and worth. Yet if that exception were not confined, then a long list of persons who provide goods and services for marriages and weddings might refuse to do so for gay persons, thus resulting in a community-wide stigma inconsistent with the history and dynamics of civil rights laws that ensure equal access to goods, services, and public accommodations. It is unexceptional that Colorado law can protect gay persons, just as it protects other classes of individuals in acquiring whatever goods and services they choose on the same terms and conditions as are offered to other members of the public. And there are no doubt innumerable goods and services that no one could argue implicate the First Amendment. Petitioners conceded, moreover, that if a baker refused to sell any goods or any cakes for gay weddings, that would be a different matter, and the state would have a strong case under this court's precedents that this would be a denial of goods and services that went beyond any protected rights of a baker who offers goods and services to the general public and is subject to a neutrally applied and generally applicable public accommodations law. So that means that Masterpiece Cakes said, no. If we didn't sell anything to gay people, that would be a problem, right? That would be a violation of the civil rights law and of their dignity, and that would not be okay. But that's not what we're doing. That's what happened here. Phillips claims, however, that a narrower issue is presented. He argues that he had to use his artistic skills to make an expressive statement, a wedding endorsement in his own voice and of his own creation. As Phillips would see the case, the contention has a significant First Amendment speech component and implicates his deep and sincere religious beliefs. In this context, the baker likely found it difficult to find a line where the customer's rights to goods and services became a demand for him to exercise the right of his own personal expression for their message, a message he could not express in a way consistent with his religious beliefs. And this has been a long-held problem, or not a problem, a long-held sort of issue with contracts, like outside of the context of discrimination. If you're having an artist who is, a specific talent that you're after, and they breach the contract, one of the remedies of breach of a contract, especially in a commercial setting, is to compel performance, right? They breached by not paying me the $500 that they owe. We want the court to compel them to provide the $500 that they owe. Or maybe the $500 is not a good example because it's money. So they were supposed to deliver me 30 bags of salt a month, and they're not. We want the court to order them to fulfill their contract, to perform and deliver me 30 bags of salt, and I will continue to pay them. That's an enforcement of the of performance. Okay, but artists. Contract law for a long time has recognized that forcing an artist to perform, you get less than the performance you're expecting and less than what you're paying for. So they don't compel performance of artists typically because of the inherent problems with that. Like, could you imagine forcing someone to sing at a concert that they were trying to break the contract for? Now, they would have to compensate you through monetary damages usually. But anyway, so in contract law, this is a long-held thing. Can't compel an artist to perform a project because you wouldn't want them to, because their art would be diminished and you wouldn't be getting what you're trying to buy. But anyway, that was a digression. Phillips' dilemma was particularly understandable given the background of legal principles and administration of the law in Colorado at that time. His decision and his actions leading to the refusal of service all occurred in the year 2012. At that point, Colorado did not recognize the validity of gay marriages performed in its own state. At the time of the events in question, this court had not issued its decisions in either United States versus Windsor or Obergefell. Since the state itself did not allow those marriages to be performed in Colorado, there is some force to the argument that the baker was not unreasonable in deeming it lawful to decline to take an action that he understood to be an expression of support for their validity when that expression was contrary to his sincerely held religious beliefs, at least insofar as his refusal was limited to refusing to create and express a message in support of gay marriage, even one planned to take place in another state. At the time, state law also afforded shopkeepers some latitude to decline to create specific messages a storekeeper considered offensive. Indeed, while enforcement proceedings against Phillips were ongoing, the Colorado Civil Rights Division itself endorsed this proposition in cases involving other bakers' creation of cakes, concluding on at least 3 occasions that a baker acted lawfully in declining to create cakes with decorations that demeaned gay persons or gay marriages. See Jack versus Ghetto Limited, Jack versus La Bakery Sensual Incorporated, and Jack versus Azucar Bakery. So lots of Frenchness here. Gâteau, La Bakerie Sensuelle, and Azucar Bakery. Is Azucar French? I mean, I know that Spanish would be similar. I don't know. There were, to be sure, responses to these arguments that the state could make when it contended for a different result in seeking the enforcement of its generally applicable state regulations of businesses that serve the public. And any decision in favor of the baker would have to be sufficiently constrained, lest all purveyors of goods and services who object to gay marriages for moral and religious reasons in effect be allowed to put up signs saying, no goods or services will be sold if they will be used for gay marriages, something that would impose a serious stigma on gay persons. But nonetheless, Phillips was entitled to the neutral and respectful consideration of his claims in all the circumstances of the case. Now, listen to what Kennedy's saying here. They might find that he can't refuse to service gays. They might find that. But in this case, he was entitled to a neutral and respectful consideration to come to the conclusion and he didn't get it. The neutral and respectful consideration to which Phillips was entitled was compromised here, however. The Civil Rights Commission's treatment of this case has some elements of a clear and impermissible hostility to the sincere religious beliefs that motivated his objection. That hostility surfaced at the Commission's formal public hearings, as shown by the record. On May 30th, 2014, the 7-member commission convened publicly to consider Phillips's case. At several points during its meeting, commissioners endorsed the view that religious beliefs cannot legitimately be carried into the public sphere or commercial domain, implying that religious beliefs and persons are less than fully welcome in Colorado's business community. One commissioner suggested that Phillips can believe, quote, what he wants to believe, but cannot act on his religious beliefs, quote, if he decides to do business in the state. A few minutes later, the commissioner restated the same position. If a businessman wants to do business in the state and he's got an issue with the laws impacting his personal belief system, he needs to look at being able to compromise. Standing alone, these statements are susceptible of different interpretations. On the one hand, they might mean simply that a business cannot refuse to provide services based on sexual orientation, regardless of the proprietor's personal views. On the other hand, they might be seen as inappropriate and dismissive comments showing lack of due consideration for Phillips' free exercise rights and the dilemma he faced. In view of the comments that followed, the latter conclusion seems more likely. On July 25, 2014, the Commission met again. This meeting, too, was conducted in public and on the record. On this occasion, another commissioner made specific references to the previous meeting's discussion, but said far more to disparage Phillips' belief. The commissioner stated, I would also like to reiterate that we said in the hearing or in the last meeting, freedom of religion and religion has been used to justify all kinds of discrimination throughout history, whether it be slavery, whether it be the Holocaust, whether it be, we can list hundreds of situations where freedom of religion has been used to justify discrimination. And to me, it is one of the most despicable pieces of rhetoric that people can use to use their religion to hurt others. Starting to sound hostile there, pal. To describe a man's faith as one of the most despicable pieces of rhetoric that people can use is to disparage his religion in at least two distinct ways, by describing it as despicable and also by characterizing it as merely rhetorical, something insubstantial and even insincere. The commissioner even went so far as to compare Phillips' invocation of his sincerely held religious beliefs to defenses of slavery and the Holocaust. This sentiment is inappropriate for a commission charged with the solemn responsibility of fair and neutral enforcement of Colorado's anti-discrimination law, a law that protects discrimination on the basis of religion as well as sexual orientation. And that paragraph might need to be framed, because that is one of the best things that Kennedy says. Because if you notice this, maybe it's just me, but if you notice this, in these little panels and stuff like that is a bunch of mini tyrants. And local government is full of mini tyrants, don't get me wrong. But you find these little weaselly people who will sit there and think that because they're on the board describing or deciding what is and isn't discriminatory, that they can be the most discriminatory and dismissive piles of garbage that you may ever meet. I mean, you can find countless examples of stuff like this from these little administrative bodies where a bunch of people with a very specific political bias go on the panel and just impose that bias on the rest of the world, ignoring what it does to affect them. And I really, really don't like that type of thing. So if that doesn't show through, I apologize, but I wanted to state it because you see that a lot. Anyway, I could ramble on about that for an hour, but I'm not gonna. The record shows no objection to these comments from the other commissioners. No objections. No one saying, hey, wait a minute, like, can we chill out a little bit? Not one. In the later state court ruling, reviewing the commission's decision did not mention those comments, much less express concern with their content. Nor were the comments by the commissioners disavowed in the briefs filed in this court. For these reasons, the court cannot avoid the conclusion that these statements cast doubt on the fairness and impartiality of the commission's adjudication of Phillips's case. Members of the court have disagreed on the question whether statements made by lawmakers may properly be taken into account in determining whether a law intentionally discriminates on the basis of religion. See Church of Lukumi Babalu I Inc. versus Scalia, concurring in part and concurring in judgment. In this case, however, the remarks were made in a very different context, by an adjudicatory body deciding a particular case. So it's questionable whether or not we can use the words of legislators in determining whether or not a law is constitutional or not. But this isn't legislators. This is an adjudicatory body deciding a particular case. This is state action without question. Another indication of hostility is the difference in treatment between Phillips' case and the cases of other bakers who objected to a requested cake on the basis of conscience and prevailed before the commission. As noted above, on at least 3 other occasions, the Civil Rights Division considered the refusal of bakers to create cakes with images that conveyed disapproval of same-sex marriage, along with religious text. Each time, the division found that the baker acted lawfully in refusing service. It made these determinations because, in the words of the division, the requested cake including wording and images the baker deemed derogatory. Jack versus Gâteau featured language and images the baker deemed hateful. Jacques versus La Bakerie Sensuelle says, or displayed a message the baker deemed as discriminatory. Jack versus Azucar Bakery. The treatment of these conscience-based objections at issue in these 3 cases contrasts with the Commission's treatment of Phillips' objection. The Commission ruled against Phillips in part on the theory that any message the requested wedding cake would carry would be attributed to the customer, not to the baker. Yet the division did not address this point in any of the other cases with respect to the cakes depicting anti-gay marriage symbolism. So in Jack's case, him making the cake and saying, hypothetically, gay marriage for the win or whatever on the cake would be attributed to the customers, not to Jack. But in the other cases where a customer came in and wanted something that was disparaging to gays, they said that they didn't even consider the fact that it would be applied to the customer buying the cake, not the baker. The commission ruled against Phillips. Oh, wait, yeah. Additionally, the division found no violation of CADA in the other cases, in part because each bakery was willing to sell other products, including those depicting Christian themes, to the prospective customers. But the commission dismissed Phillips' willingness to sell birthday cakes, shower cakes, and cookies and brownies to gay and lesbian customers as irrelevant. The treatment of the other cases in Phillips' case could reasonably be interpreted as being inconsistent as to the question of whether speech is involved, quite apart from whether the cases should ultimately be distinguished. In short, the Commission's consideration of Phillips' religious objection did not accord with its treatment of these other objections. Before the Colorado Court of Appeals, Phillips protested that the disparity in treatment reflected hostility on the part of the Commission toward his beliefs. He argued that the Commission had treated the other bakers' conscience-based objections as legitimate, but treated his as illegitimate, thus sitting in judgment of his religious beliefs themselves. Court of Appeals addressed the disparity only in passing, and relegated its complete analysis of the issue to a footnote. Sorry, that's, Kennedy doesn't like that. There, the court stated that this case is distinguishable from the Colorado Civil Rights Division's recent findings that other bakeries in Denver did not discriminate against a Christian patron on the basis of his creed when they refused to create the requested cakes. In those cases, the court continued there was no impermissible discrimination because, quote, the division found that the bakeries refused the patron's request because of the offensive nature of the requested message. And this is why we can't base laws on offensiveness, because what's offensive to you isn't offensive to someone else, and what's offensive to someone else isn't offensive to you. A principled rationale for the difference in treatment of these 2 instances cannot be based on the government's own assessment of offensiveness. Just as no official high or petty can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, that's West Virginia Board of Education or Educators versus Barnett, it is not, as the court has repeatedly held, the role of the state or its officials to prescribe what shall be offensive. Remember that line. Remember that line over the next several months. It is not, as the court has repeatedly held, the role of the state or its officials to prescribe what shall be offensive. See Mattal versus Tam. Ugh. Can we get that just blared out? Like the state should back off from anything, like from trying to deem things offensive. Citing Mattal versus Tam, opinion of Alito. The Colorado court's attempt to account for the differences in treatment elevates one view of what is offensive over another and itself sends a signal of official disapproval of Phillips' religious beliefs. The court's footnote does not, therefore, answer the baker's concern that the state's practice was to disfavor the religious basis of his objection. For the reasons just described, the commission's treatment of Phillips' case violated the state's duty under the First Amendment not to base laws or regulations on hostility to religion or religious viewpoint. In Church of Lukumi Babalu I, the court made clear that the government, if it is to respect the Constitution's guarantee of free exercise, cannot impose regulations that are hostile to the religious beliefs of affected citizens and cannot act in a manner that passes judgment upon or presupposes the illegitimacy of religious beliefs and practices. The Free Exercise Clause bars even subtle departures from neutrality on matters of religion. Here, that means the Commission was obligated under the Free Exercise Clause to proceed in a manner neutral toward and tolerant of Phillips' religious beliefs. The Constitution commits government itself to religious tolerance, and upon even slight suspicion that proposals for state intervention stem from animosity to religion or distrust of its practices, all officials must pause to remember their own high duty to the Constitution and to the rights it secures. Factors relevant to the assessment of governmental neutrality include, quote, the historical background of the decision under challenge, the specific series of events leading to the enactment or official policy in question, and legislative or administrative history, including contemporaneous statements made by members of the decision-making body. In view of these factors, the record here demonstrates that the Commission's consideration of Phillips' case was neither tolerant nor respectful of Phillips' religious beliefs. The Commission gave every appearance of adjudicating Phillips' religious objection based on negative normative evaluation of the particular justification for his objection and the religious grounds for it. It hardly requires restating that government has no role in deciding or even suggesting whether the religious ground for Phillips' conscience-based objection is legitimate or illegitimate. On these facts, the court must draw the inference that Phillips' religious objection was not considered with the neutrality that the Free Exercise Clause requires. Now, it is important to note, outside of this case, it's not mentioned here, that while it is not the government's job to determine whether or not a belief is that's held on religious ground is legitimate or illegitimate, it is the court's job to determine whether or not said belief is sincerely held, and the parties may bring evidence to argue that it is or is not a sincerely held belief. So if your sincerely held belief is that you're opposed to gay marriage, yet you are gay married in some state, like maybe for insurance purposes or whatever, like you're trying to cheat the system, like that was that movie with was it Kevin Smith and Adam Sandler or whatever? Meet Chuck and whatever. I don't know. I don't remember the title, but you guys know what I'm talking about. Like if you had a fake gay marriage, but then you said you're viscerally opposed to gay marriage based on your religious beliefs, they would say, well, that's an insincere belief or something like that. Or maybe he baked a cake for his own child's gay marriage that would then undermine that sincerely held belief thing. Okay. So it is the state's purview to justify the sincerity of the held belief, but not the legitimacy of the held belief. So there is a distinction there. While the issues here are difficult to resolve, it must be concluded that the state's interest could have been weighed against Phillips' sincere religious objections in a way consistent with the requisite religious neutrality that must be strictly observed. The official expressions of hostility to religion in some of the commissioner's comments that were not disavowed at the commission or by the state at any point in the proceedings that led to affirmance of the order, were inconsistent with what the Free Exercise Clause requires. The Commission's disparate consideration of Phillips' case compared to the cases of other bakers suggests the same. For these reasons, the order must be set aside. The Commission's hostility was inconsistent with the First Amendment's guarantee that our laws be applied in a manner that is neutral toward religion. Phillips was entitled to a neutral decision maker who would give full and fair consideration to his religious objection as he sought to assert it in all of the circumstances in which this case was presented, considered, and decided. In this case, the adjudication concerned a context that may well be different going forward in the respects noted above. However, later cases raising these or similar concerns are resolved in the future. For these reasons, the rulings of the Commission and the state court that enforced the Commission's order must be invalidated. The outcome of cases like this in other circumstances must await further elaboration in the courts, all in the context of recognizing that these disputes must be resolved with tolerance, without undue disrespect to sincere religious beliefs, and without subjecting gay persons to indignities when they seek goods and services in an open market. The judgment of the Colorado Court of Appeals is reversed. It is so ordered. That is done. As I said, I will not be reading the next 14 pages to you, 15 pages to you, because that would take a long time. Kagan. I'm not going to read it, but let me just paraphrase what she says. She says that she supports this motion or this decision because it's clear that the court doesn't say that the baker can't refuse services or can refuse services to gay people. It's only supporting the fact that the board deciding it was hostile and neutral. And had the board reached the same conclusion while being neutral, or hostile and not neutral, if it had reached the same conclusion while being neutral, everything would be fine. And then you have Gorsuch and Alito saying the opposite, basically that it would be impossible for them to reach the same decision while being neutral. And so you have a little bit of argument there. Anyway, if you want more information, guys, read the full decision or ask me questions in the comments, and I would be happy to talk about it. But that's that. So all of the people who are out there, like either cheering or bemoaning the fact that you can refuse service to gays, don't listen. They've got the case wrong. Remember, this case is about whether or not the administrative body was hostile towards, was impermissibly hostile towards Phillips' religion in applying the Colorado Anti-Discrimination Act to his refusal of service, refusal to sell a wedding cake to a gay couple who is getting married in Massachusetts while gay marriage was illegal in Colorado. It really needs to be that precise. This is a limited decision in that respect, and any other set of facts is going to change the outcome dramatically. I would wager that had they been neutral, that this would not, that the Supreme Court would have ruled a completely different way. I think that is coming. I don't think it's correct, but I think it is coming that they will say that that this refusal is not a valid exercise of the First Amendment rights. It is important to note that Phillips has also stopped selling wedding cakes entirely. And he has said that it has lost him 40% of his business to do that. But that is how sincerely he held his religious belief, that he stopped selling any wedding cakes so as not to be discriminatory in his practices any longer. It is not clear whether or not he will start selling wedding cakes again after winning this decision, but I would suggest to him that he not, because if he does, and he does it in the same way, he very likely is still in violation of the law. So I hope that was useful and helpful to you. I hope that cuts through some of the stuff. I am going to record a very short video talking about what this case actually says as sort of a summary. So if you watched this one first, good job, sucker. But yeah. Anyway, guys, thank you for joining me tonight. Hope you found this useful. Hope you learned a little bit about how the Supreme Court works through these issues and how important it is to figure out what question the Supreme Court is answering. Otherwise, you may take a decision like Marsh and say that because the Supreme Court in a particular town that was owned by a corporation that was trying to control people's speech ruled that a public or a private place could have First Amendment protections applied to it, doesn't apply to YouTube and Twitter and stuff like that in the modern days, because you're asking the wrong question that the court is trying to answer. So there is a video probably coming out. There's a video coming out on Twitter being a public forum in regards to the recent ruling against Trump. And I will be talking about that Marsh decision as well. So stay tuned for that if you're interested in more Supreme Court stuff and how to interpret the appropriate federal question when you're reading through a case. So anyway, thanks guys, and see you soon. Peace.